Good afternoon, ladies and gentlemen. I welcome you all to one more chapter of the BRATECC webinar series. In this event, we will be talking about insolvency in the US and Brazil, what's happening. Bringing to you a long-time BRATECC member, Foley and Lardner, who will be moderating this event. My name is Ulisses Sperandio, and I'm the president of BRATECC. BRATECC's objective is the promotion and advancement of commercial trade and investment between Brazil and the US through Texas, by way of conferences, seminars, meetings, missions, publications, education, and social activities, as well as through other means of communication. Texas used as the entry door to the US market. Similarly, we also support the US companies interested in doing business in Brazil. Our focus is the oil and gas industry, but we also have presence and provide support to other areas such as agribusiness and import and export, and other areas that have interest in doing business with the US. We rely on our extensive network of member companies that can provide the necessary support to start your business in the US, such as law firms, accounting houses, immigration support, as well as provide physical spaces for offices and warehouses for your company to start and to have an easy startup in the US. Additionally, Brazil can provide access to an extensive network, Additionally, BRATECC can provide access to an extensive network of organizations and companies based in Texas, such as the Brazilian Consulate in Houston, the Office of the Texas Governor, the AmCham, which is American Chamber of Commerce, the Greater Houston Partnership and the Port of Houston, also the major oil and gas companies such as Exxon, Chevron, BP, Schlumberger, Schwest, and many others, and a good level of law firms and accounting houses that are all part of our members, such as Foley and Lardner that is here today with us. Today's objective is to provide you with a discussion and options on how to deal with insolvency in the US and Brazil. And without any further delays, I will pass on the microphone to Pedro Fragoso, who is the foreign legal consultant of Foley and Lardner, who will be our moderator today. And Pedro will introduce all the other panelists. So if you may, Pedro, go ahead.
Thank you very much, Ulisses. It's great to be here. Thanks for the audience for joining such an important event, very timely event. Before I move to the introductions of our panelists, I have an announcement to make it. One of the speakers, Brittany Nelson, she had a health-related emergency this morning on a very short notice, and unfortunately, she won't be able to attend this webinar. The good news is that my partner, John Melko, is gonna cover her. He was already planned to speak as one of the panelists in this event, and he's gonna cover Brittany's piece as the chair of our bankruptcy practice with Foley and Lardner. So speaking about John's practice focused on complex sales, acquisitions, bankruptcies, and finances in the energy sector throughout the United States, as well as shipping-related issues in both foreign and domestic cases. John has years of cross-border and multinational experience with oil and gas exploration and production, refining and marketing, airlines, telecommunications, electric utilities, manufacturing, retail, rig and ship finance, mass torts, and asset-backed securities. Throughout his career, John has helped guide clients through dislocations in the energy, shipping, telecommunications, real estate, and healthcare markets, utilizing Chapter 7, Chapter 11, and Chapter 15 procedures. John, as I mentioned, serves as the co-chair of the firm's bankruptcy and business reorganization practice, and the vice chair of the firm's oil and gas industry team. We will also have today two other speakers, very prominent, very regarded in Brazil. We'll have Celso Xavier. Celso is a board member of Demarest and a partner in the litigation, arbitration, and corporate restructuring group. He has a bachelor's degree in law from PUC São Paulo and a master's degree in law from Stanford. His practice concentrates on complex litigation with a focus on contractual disputes, crimes, cartel disputes, product liability, and judicial reorganization. He has extensive experience in the areas of banking, investment, construction, engineering, oil and gas, automotive, life sciences, consumer goods, and technology. He has also worked as an international lawyer at Fenwick and West in the United States. And last but not least, we have Otto Lobo. Otto is a founding partner of Lobo and Martin Advogados. His practice focuses on complex arbitration and litigation, including corporate restructuring and in courts insolvency matters. His experience includes representing businesses, including public and private companies and pension funds, nonprofit organizations, and other entities in a number of litigation arbitration matters, including bankruptcy procedures. He is a former member of the Council of Appeals, which rules on appeals from decisions of the Brazilian Securities and Exchange Commission and the Brazilian Central Bank, and is a professor of corporate law and capital markets. Otto has a bachelor's degree in law from PUC Rio, a master's degree in law from the University of Miami, and is doing his doctoral degree in commercial law at the University of São Paulo. Otto was also a partner of the former Miami-based law firm Steele, Hector and Davis. Regarding our topic, Chapter 11 versus Bill 4458, 2020, insolvency in the US and Brazil. What's happening? You should know that Brazilian Congress has just approved Bill 4458, 2020, which will incorporate the UNCITRAL Protocol. We are expecting President Bolsonaro to approve this bill in the 2 upcoming weeks. So this event is very timely for that. We'll have, in terms of format of this event, we have Celso and Otto covering the Brazil side, talking about the new Brazilian bankruptcy law and share with us their practical experiences, including the Latam case, which is deemed to be the leading case of a Brazilian company filing for Chapter 11 in the US rather than filing in Brazil. As you may know, historically, the Brazilian companies, they file for Chapter 11 in Brazil and Chapter 11 in the US. So Latam was one of the first cases, if not the first case, where they decided to file in the US. So we are pleased to have Celso here to share with us his practical experience and the motivations for such a company filing in the US rather than in Brazil. At the end, we'll have our Q&A session. We are reserving 10 minutes for that, but depending on how this webinar goes, the discussions and so on, we might extend it. And we will invite all the attendees to stay if you wish to submit any questions. As a final announcement, this event is being broadcast live by YouTube. So without further ado, I will turn it over to Celso for his speech. Celso, the floor is all yours.
Thank you very much, Pedro. Thank you, Ulisses, for giving us the opportunity to use the platform of BRATECC for such a very interesting seminar. I think we have a lot to discuss and a lot to learn from each other. I mean, whenever we have such a topic discussion on transnational insolvency, there are always issues related to both countries that will come up, and I think that's the reason why we are here. So please jump in, John, Pedro, and Otto. If you have any comment, any question, please just interrupt me. Well, just to give you and the attendees initial idea of this new bill. This is a very old bill, let's put it this way, because it was under discussion at the Brazilian Congress for quite a few years. But like most of things in Brazil, I mean, it takes time to be approved and to be discussed. I think in 2019, the House of Representatives decided to create a specific committee of practitioners, of professors of law and in the insolvency field to really go deeper in the bill and try to bring changes that will be useful for the market, useful for creditors and for debtors. So as of 2019, I think this bill has really gained the characteristics we're gonna talk a little bit about, and in the end of the day, how it has been approved by the House of Representatives and ultimately by the Senate. Obviously, that what happened this year with all the COVID-19 speeded up the process of approval because I mean a lot of businessmen in Brazil went bankrupt, decided to apply for the Brazilian judicial reorganization that would be the Chapter 11 equivalent, or even out of court reorganizations. And so this, I would say this requirement, this demand from the audience really to have a better law that would both reflect hurdles that the old law was putting to the practitioners, as well as really innovations that would be expected by Brazilians and by companies. The COVID-19 speeded up everything. And then very, very quickly, the House of Representatives approved that. The bill went to the Senate and it was approved. And now it's just waiting for the sanction, which is the validation by President Bolsonaro to be effective. Once this sanction takes place, this amendment to our bankruptcy law will be published in an official gazette, and then it's going to start being effective after 30 days. So we expect in Brazil that sanction will take place within this year. That's the expectation. So probably we should have the amended law working and effective as of early February or so. Okay. This new, I wouldn't say new law, but this new bill that amended the old law pretty much has two different pillars, let's put this way. In the first pillar, I would say that it addresses concerns that practitioners used to have, things that Brazilian case law had already changed and addressed, and a few improvements based upon international experience. So this is one specific field. The other field is the incorporation in Brazil of the UNCITRAL model law for transnational insolvency. That pretty much we had nothing in our law dated 2005. And I would say not only, but motivated by the Lardner case, there was a need, or at least one more demand from practitioners really to have such an incorporation into Brazilian law, and several discussions on the reasons why Lardner decided to apply for a Chapter 11 instead of commencing any insolvency procedure in Brazil. And to the extent it's possible, I will try to address that a little bit. Okay, I'm going to leave this first field for Otto to address the main changes, and then we can come back to that in more specifics, because there are really very interesting things that, from my perspective, will booster the economy in the country, will cause our judicial organization to be a more effective process, not only in terms of the timeline, of the timing to have it concluded, but I would say in terms of the recovery it may bring to creditors, and the ability that the process will have to really recover the business, and not only being one stage precedent to a true liquidation. But let's get started by the UNCITRAL. As you know, that there is this UNCITRAL model law. Quite a few countries have, I mean, a long time ago incorporated that with some changes, but not changes that will be really significant in the essence of this model law. And this is exactly what Brazil decided to do now. So pretty much what we have in the amendment, it's substantially the UNCITRAL model law, okay? So we are likely to have, as of, let's say, February, if sanction takes place still in December, Brazil becoming a member of these countries which admit to have transnational insolvency and really, in essence, enforce decisions that would be handed down in different countries by having procedures in Brazil that will be just ancillary to main procedures that will take place in the US or in any country in Europe, and so on and so forth, without really discussing the merits of decisions made there, but just discussing to what extent this other place, the main procedure has been filed in the main center of business in the COMI in an adequate fashion, and because of that, Brazil should be seen just an ancillary jurisdiction to protect the interests of the debtors, the assets of the debtors, and then the interest of the creditors as well. But the question is there any relation between this UNCITRAL model law and the approval with the Latin case? So put in a different way, in case this amendment would be effective when Latin decided to apply for Chapter 11, would that have changed Latin's mind, Latin's point of view, to seek protection in the US instead of seeking protection in Brazil? And my inclination is to say no. When Latin decided to apply for a Chapter 11, a lot of professors of law and very good practitioners started to say, well, our law is really bad, and that's the reason why even Brazilian companies, they are going abroad to seek protection. I mean, I heard that quite a few times. And this was not a fair statement. I mean, Latin decided to apply for a Chapter 11 for other reasons, not because the Brazilian system is not good, not because the law is not good. And I'm going to tell you in a while. So, I mean, there's no cause and causation and consequence between these two things, even though I honestly believe that this fact has caused the bill to be approved in a faster way, exactly to have Brazil as a tier 1 country in terms of insolvency, in transnational insolvency. But the reason why Latin applied in the US, it's quite simple, and there's only one answer. It's money. The reason is economic. I mean, the group had applied for Chapter 11 beforehand, so the whole group applied for that in May 2020, but not the Brazilian entities. The Brazilian entities decided not to do that at that point in time. As you know, the airline industry probably has been one of the most affected by the COVID-19 crisis for obvious reasons. I'm not even spend a second on this. And then the question was that, well, we are facing a crisis that we have no idea when this will be finished. So I have no idea if my money I have in my pocket will be sufficient for 2, 3, 4, 1 year. We don't know. Even now, we don't know when the COVID-19 will be ended. So at that point in time, I mean, all the airline companies worked with precaution to say that, well, we need to save as much money as we could. We don't know when our aircraft will take off again, at least at the same levels we use it to have. So we're going to need new money to move forward and get around this crisis. And so the question from a Brazilian perspective was that, well, either I get money from Brazilian banks or I get money from international financial institutions, could be a bank or hedge funds or so. And then a discussion has been, I mean, disclosed by the press with Brazilian banks, private and public, started taking place, but unfortunately has not evolved in the pace that the companies would like, not because of the banks themselves, but because of the bureaucracy that involves that, and because the crisis has affected not only that industry, but other industries as well, such an unprecedented crisis.
And Celso,
And then,
if I
sure.
can break in for a moment, this is John. Where was the existing debt issued? Was that dollar-denominated debt, and who were your lead lenders?
That's a good question, John. The indebtedness of the Latin group as a whole, but precisely about Brazil that I'm more familiar with, I mean, it was not huge. I mean, provided that the company, that COVID-19 had not taken place, I mean, if you had to compare the revenues and indebtedness, it was absolutely adequate. I mean, the proportional, the ratio, it was okay. I mean, the company had money, still has money, but had money at that point in time to survive for, I mean, quite a few months. There was no specific maturity that would take place very soon that was like threatening the company, nothing like that. But the company had to work with precaution exactly because it had no clue on whether the crisis would, I mean, last for 2 months or a year or even more. So it was more like when we learned from our financial advisors in every single insolvency and say that, well, don't expect for you to be owing money to everyone to start an insolvency procedure, because then your capacity to recover will be very low. So when you feel that your business, you still have cash, but there is a trend that is going to be down, that's the right moment to apply for something and start thinking about that. And so that was the rationale of Latam Brazil. And then after a month or so in July, I mean, there was an expectation that in the context of the Chapter 11 of the other companies of the group, there might be lenders willing to be interested in the case, in essence. And so the Brazilian group decided to join the Chapter 11 of Latam, exactly to benefit from any money that might come at that point. Had no certainty, but that was the expectation. And this, in the end of the day, what happened, as you know, it has been disclosed to the market that the whole group managed to get a deep loan, a very important one, that has given to the company comfort to really get around such an unprecedented crisis. So the reason why the Brazilian company decided to do that, it was exactly that, not any lack of trust in the Brazilian legal system or in the Brazilian court, absolutely nothing. It's just because lending money to insolvent companies in US, it's something that you've been doing, and John, you could comment, for decades. And in Brazil, it's a new practice that would say that even this amendment, as probably as Otto is going to mention, now we have specific rules on new money, on deep loans. So I believe that we're going to start having such a culture in terms of priority and a new business and the need of new money by debtors in judicial organizations in Brazil. But this is new, okay? What really helped it quite a lot, and this was a concern we had, was that, well, okay, but we are going to the US. Some of our creditors, they are based in the US. A few of them, they are not based in the US, and most of them, they are based in Brazil. So even though the US bankruptcy law acknowledged that, well, creditors are subject regardless of where they are, the question would be that how Brazilian courts would interpret that. And this is a very particular thing, John, that I'd like to hear as well, which is about the first day motions, which pretty much has granted to Latam the ability to pay under certain conditions and requirements some pre-petition debts, especially those related to customers' claims, I mean, baggage claims, you know, and labor claims, which as an airline company in Brazil, it's a very litigious country, is the majority of the litigation the companies have here in this country. So in the end of the day, because of such authorization that obviously has been used with a lot of caution and supervision by the UCC and the US court, it has been very important, in essence, to avoid litigation in Brazil. And so it's a process that is going very smooth and very, very well so far, and very successful. And Pedro, I'm going to stop here to give the floor to Otto and to John. We may come back to perhaps issues we may discuss on this, okay? You are on mute. Pedro, you were on mute.
Sorry. Thank you, Celso. So we now have Otto comment on that, maybe cover some of the changes in the new law in Brazil, the amendment. And afterwards, we're going to have John explain how the new changes in Brazil, they mesh with the US law. So Otto, please.
Thank you, Pedro. First, I want to thank the BRATECC Brazil, Texas Chamber of Commerce. And I want to thank Mr. Ulisses Sperandio for this opportunity. I also want to thank Pedro Romano from Foley and Lardner LLP for organizing, once again, another very high-end, very interesting debate. Pedro has been very active in the Chamber of Commerce in Miami and now in Texas and in other events. So I thank you. So I want to also congratulate Celso Xavier on the work that he's been carrying out in the Latam Chapter 11 case, which, as I will comment, is one of the, I think is the first case of Chapter 11 of a Brazilian company, and it's a tendency since 2016. Several Latin American countries had filed for Chapter 11 for several reasons. Celso has already mentioned some of the reasons for this filing. I want to also congratulate John Melko, who is a very active attorney, insolvency attorney, has been doing this for a long time, but he started very early, so he still looks very young. And I want to say all the best to Brittany, and I understand that Brittany had an emergency today, and we hope everything is well, and all the best to her. So just very quickly, I wanted to mention that this Chapter 11 case is a cross-border insolvency case, and arguably it is a case of forum shopping. There is a lot of discussion as to forum shopping and common migration. So I wanted to talk a little bit about that, because specifically PL 4458, which is the bill that will amend our law 11,101, it has a specific article on forum shopping and common migration. So that's one of the issues that I wanted to talk about also today. As everybody knows by now, and our insolvency law currently in place is 11,101 from 2005. It did not adopt cross-border insolvency rules. This had a consequence on the development of the national economy. The country has always been less attractive for foreign capital investment. At the time, the 2005, our legislator adopted a territoriality model, and Article 3 of the law 11,101 provides that. And after that law has been enforced for some time, we found, all of the attorneys have found that the cross-border insolvency rules, the lack of cross-border, generated several difficulties. And for one thing, since 2005, Brazilian companies have filed for up to 30 Chapter 15 procedures in the United States, and these are not these are the ancillary procedures, as John I think will mention, but these are different than what has been filed by Latam, which is a Chapter 11 procedure. Then, for the first time, a Brazilian company, Brazil was not very attractive for foreign investment because these multinational companies that have a worldwide presence nowadays, they choose jurisdictions depending also on the insolvency law and how the insolvency law treats foreign creditors in comparison to local creditors. This bill initially, it was Bill of Law 6229 of 05 that would reform the law in the Chamber of Deputies, and now in the Federal Senate approved, as Celso mentioned, PL 4458. Expectation is, I spoke to one of the commission members today. He mentioned that it should be signed by December 24, before Christmas. So as Celso mentioned, Brazil has adopted the UNCITRAL model law on its chapter 6A. Relevant rules of recognition of foreign procedure, according to the UNCITRAL model law in its article 167J. However, there's a specific mechanism in 167J, and I've wrote an article that I will publish by beginning of next year. There's a specific paragraph 2 of Article 167J that determines that when there is a transfer of COMI or a manipulation in order to transfer the competence or jurisdiction of another state, that procedure will not be recognized in Brazil as a foreign main procedure. That's a specific Article 167J. And so I will comment briefly as to the implications, possibly the implications of that specific article, because we are once again talking about possibly forum shopping. When Latam decided to file in New York, and initially Latam did not file with the other companies. It was still, I think, at the time waiting for negotiations with BNDES, but it arguably there is a discussion, ongoing discussion, that some of the I think very few creditors disputed the Chapter 11 in New York. A lot of the creditors accepted, the banks accepted the jurisdiction in New York for the Chapter 11, but there is a discussion as to, according to Article 3 of the current law, if the main establishment of Latam is in São Paulo. And that is a discussion that will change according to the enactment of the new law and the discussion of COMI. So the current wording of this article 167J, paragraph 2 of 167J, I'll comment a little bit more. But just briefly, forum shopping in cases of transnational insolvency, cross-border insolvency, part of the doctrine, and that's something that I wanted to comment a little bit more, and the jurisprudence, they believe that it should be prohibited or limited, the forum shopping. The UNCITRAL law talks about foreign shopping. The concept of foreign shopping, and it's not only a concept of cross-border insolvency cases, but litigation in general that addresses. Here in this case, as I mentioned, several Latin American countries began since 2016 filing the Chapter 11 cases in usually the Southern District of New York. And the reason for this COMI migration or forum shopping, which is choosing a jurisdiction that will give you some tactical procedural advantages, is that certain aspects of our current law, 11,101, do not allow certain aspects, certain needs that Latam had at the time. I think Celso mentioned deep financing, and Bill 4558 already has mechanisms for deep financing. But one of the issues is regulation will take you so far, because part of the advantages of filing, and Latam has obviously analyzed this, of filing a Chapter 11 in New York, is not only the law, but also the experience and the industry and the financing that is available, the deep financing track record that is available in New York. The UNCITRAL model law, as I think everybody knows by now, it was done in order to also reduce transaction costs. A foreign investor, when he looks into a country, if he sees that this country has adopted the UNCITRAL model law on cross-border insolvency, he knows in advance the basic principles of this law of this country. So this simplifies the understanding of the insolvency system that was adopted when the UNCITRAL model has been adopted. We know that the UNCITRAL model has been adopted in major countries: Colombia, Japan, Mexico, New Zealand, Montenegro, Serbia, South Africa, and also the United Kingdom and Northern Ireland, the United States, Australia, and now the model has been adopted in Brazil. Basically, the model law, it provides several objectives. One is cooperation between courts, greater legal certainty of trade and investment, equitable and efficient administration of international insolvencies, protection, valuation of the debtor's assets, and it facilitates the rescue of these companies in difficulty. The idea to reform our law, which the 11,000, our law from 2005, the first experience with the cross-border insolvency cases, and one of the first one I worked was the BRATECC case in 2005. Right from the start, we saw that in these cross-border insolvency cases where you have assets and interests in several different jurisdictions, one of the initial difficulties we saw in the BRATECC case was several issues in terms of communication between judges, lack of cross-border insolvency rules, lack of the experience. And right now, I think with the new law, with Bill 4458, that will be enacted by the end of the year, in the drafting procedure of this new law, what happened was that the committee decided to focus on 10 points that they considered essential. So these points were focused, as Celso very well put. The idea was to not change several principles, institutes, several articles of the current law, which have already been interpreted by the Superior Court of Justice in the last 15 years. Because if the committee would have changed that, it would open this for 15 years in the Superior Court of Justice. One of the issues that Latam faced, and that all of these companies that have filed Chapter 11, is, as Celso already mentioned, is a definition of come, which is a center of main interest. And the definition of come, it is crucial in transnational insolvency. We know that the UNCITRAL model law and the European regulation, they deal with the concept of come all the time. And we know also that there is a presumption, it can be proven to the contrary, that the come of a debtor is the location of its registered office, the main office. And this is provided under Article 6, Item 3 of the model law. So when we talk about this concept of forum shopping, which is to choose the choice of jurisdiction, which is more favorable to the plaintiff, and every time you have a situation in which there are competing international jurisdictions, this activity of forum shopping, part of the learned commentators and part of the jurisprudence, they see forum shopping as something negative, sometimes interpreted negatively. They see it as in a derogatory way. The interpretation is not always supportive of forum shopping. But as we will see also, several important cases, and I cite here Atlantic Star versus Owners or Bonaspex, which is an important case that has been ruled before. It sees forum shopping as something natural. An insolvent company which has an option to choose between a jurisdiction that is more advantageous to its needs, this jurisdiction that is more favorable to the interests and needs, this choice of jurisdiction should not cause a surprise or an outrage in the learned commentators and the courts. This is something that happened again and again in Europe and the US. And I see personally that it's a legitimate interest of the plaintiff of the company insolvency to choose, as long as, and this I think is the important issue that we should consider in our new law, as long as this is not done as a way of a fraud and as a way of bringing some additional detriment to the creditor, loss of value to the creditor, as long as this is done as the way Latam did it in New York, in which the creditors, the very large creditors, approved this. They welcomed this. The large banks negotiated in New York the deep financing. As long as it's done in this way, I don't see forum shopping as something detrimental, but I see that sometimes in discussions here in Brazil, forum shopping is still seen as something detrimental, as something that should be avoided. I mentioned also another case, important case, Ocean Rig, UDW Inc., in which Lord Simon, he mentions the naturality of the plaintiff to choose a place where he believes his legitimate interests will be best defended. So I think that we have to have an understanding of the forum shopping and its advantages. There's an article from Pamela Bookman in which she mentions several advantages of forum shopping. And basically the protection of access to justice, promoting compliance or private regulation, and promoting legislative reform. And I can mention that seeing these cases, these 30 Chapter 15 cases that were filed in the US by Brazilian companies, there has been a promotion of legislative reform. The experience of these judges, of the attorneys, and we in Brazil, it's important to mention that São Paulo and Rio, we have specialized courts, singular judges, and in São Paulo we also have the appeals court, which is specialized. These are judges that study sophisticated commercial issues, and so there has been a legislative reform in Brazil, which is very important. And I have to mention also that in the US there are cases in which the courts can review the decision in which the judge has accepted the jurisdiction. And the court will review based on whether it's more convenient, the doctrine of forum non-convenient, and also the second is based on international comity. And this is something that the Brazilian judges and courts, I think, will interpret also when they decide whether they will have jurisdiction in the future with the new law. I cite here National Bank of Anguilla, private banking trust, which is a recent case of the Southern District of New York. In this case, the court rejected the disputes and understood that the appropriate forum would not be New York for these claims. So in the case of the enactment of this bill and in the future cases that will be ruled in Brazil, a matter of concern, as I mentioned before, is this paragraph 2 of Article 167J of the Bill of Law. Because there, if we look at this specific article, it mentions that, and I think this has to be interpreted with a lot of care, that if in determining that the foreign case will be recognized in Brazil as a non-main foreign procedure, if it says that it will be recognized as a non-main foreign procedure if the debtor's common, and I quote this, has been transferred or otherwise manipulated with the objective of transferring the competence jurisdiction of the process to another state. This is basically the definition closely to forum shopping. And paragraph 2 of 167J states, notwithstanding the provisions of paragraph 1 and 2 of paragraph 1 of this article, the foreign process will be recognized as a non-main foreign process if the debtor's center of main interest has been transferred or otherwise manipulated. So these specific parts of the law, there is an interpretation that possibly when there is forum shopping, as happened now with Latam, that the judiciary in Brazil will not recognize these procedures as foreign main procedures. And so that's a matter of concern that we will have to see how this plays out. But I've wrote an article looking into this, just because, as I mentioned before, there are several advantages to and I would mention the Latam case as a good example of a positive forum shopping called immigration, in which in which several creditors have accepted the jurisdiction. There were some creditors that very few that are disputing this based on Article 3 of 11,101 and the fact that under the terms of the Civil Procedure Code 961 and 963, currently the current law determines that you have to take a ruling to the Superior Court of Justice. So that ruling can be ratified and can be effective in Brazil. And there are some creditors that are disputing the possibility of recognizing this decision that has been rendered in the Chapter 11 case. But if one of the concerns in this new law is if there is not a very precise definition of what forum shopping is and its benefits, we will see a situation as now where Latam has not brought this ruling from New York to Brazil, but has taken this ruling, other Latam companies, to other countries which recognize forum shopping. So those are my initial comments. I wanted to once again thank Pedro Romano and BRATECC and congratulate Celso and John already on what he will still present to us. But from the conversations this week, I think you will have some very interesting points.
Thank you, Otto, and thank you to BRATECC and my co-panelist and moderator. Otto, it's interesting because in fact, I have argued and said this publicly in a seminar that a lawyer for the debtor has a fiduciary duty to identify the best jurisdiction for its client. And I remember a very prominent judge was sitting on a panel with me and looked at me sort of in surprise. And then by the end of the panel seemed to have come around to accepted the view. I want to talk about this recognition issue that you raised, because it seems to me that one of the issues, let's break it down into procedure and then substance. So, as you know, in the US, it is very easy to establish sufficient jurisdiction, a sufficient basis for a company to be a Chapter 11 debtor in the United States. There is a provision in our bankruptcy code that says if the debtor has assets within the judicial district, it can be a debtor in the United States. And cases there are reported opinions where jurisdiction over foreign companies have been upheld on assets as slim as the retainer that was paid to the financial advisor, or in some cases to the lawyer. I think in our discussions I mentioned a couple of years ago in New York, I filed a Chapter 11 case for a Cyprus incorporated shipping company that had its headquarters in London. It did business all over the world. It had correspondent offices all over. We had a bank account in New York, very small presence in New York. We filed it in New York. So, on the jurisdictional issue, the U.S. may be a little bit easier to establish primary jurisdiction in the bankruptcy court first. That begs the question of whether that's really the center of main interest. Now, let's talk about the procedure. The procedure, in order to have the judge accept the case, is, and certainly if you're filing a Chapter 15 case, or if you're alerting the court that this is a case in which you're going to have a foreign representative, you're going to ask that the chief restructuring officer or chief executive officer or whomever be recognized as foreign representative. There has to be some finding that basis is appropriate in the U.S. and creditors have the right to come in and contest jurisdiction. On the other side of the docket, and it was another shipping case, but it was here in Houston, we represented represented, I think, 4 bank consortiums out of like 16 or something that were contesting the jurisdiction in the U.S. of the bankruptcy courts over a Taiwanese shipping company, TMT Enterprises. And we had a week-long trial on that. And at the end of that process, the bankruptcy court found that there was sufficient jurisdiction in the U.S. Now, that's just establishing sort of your beachhead jurisdiction. If a creditor in the home jurisdiction, so let's say in Taiwan, I don't think Taiwan would have been a signatory, but let's take my other shipping case in the UK where I was debtor's counsel. If a UK-based creditor objected to the treatment that it got through the plan of reorganization, it could have said two things. It could have said, you shouldn't recognize this, Your Honor, because the center of main interest should never have been New York. It should have been in the UK. A British court might have refused to uphold that judgment. Or alternatively, and we've seen this in the US and we've seen it in the UK, the court could have said that judgment that was entered by a court in another country was correct and there was due process under the laws of that country, but it was not in accordance with US law. I'll give you two examples. In the United States, there was a Chapter 11 and a Chapter 15 filed for a very large international glass company, makes windows for skyscrapers and all sorts of glass applications, called Vitro, V-I-T-R-O. Vitro also filed a concorso in Mexico. The U.S. bankruptcy judge, and in the concorso, their own restructuring provision, the bankruptcy judge in Mexico, in Mexico, entered a judgment that said, I'm going to approve this plan of reorganization. And part of this plan of reorganization is I'm going to release from their guarantees subsidiaries or affiliates of the debtor, which are not in bankruptcy, even though those affiliates are not contributing anything to the bankruptcy. In other words, they were getting off the guarantees for nothing, just to put it bluntly. The bankruptcy judge in the US that had the Chapter 15 refused to recognize that plan because he said that provision where you release guarantors for nothing is inimical against all concepts of US law, that where you can have these releases, but the party being released has to put some money in that is found to be fair consideration for that release. There was another case where a U.S. bankruptcy trustee took a judgment against a UK individual in Rubin versus Eurofinance, which at the time was a very well-known case, and international lawyers were running around screaming, this case is going to be the death of comedy, because the UK court refused to enforce the judgment that the bankruptcy trustee had gotten out of a court in the US. And I started to write an article with a friend of mine who's a bankruptcy practitioner in the UK, and we quickly concluded that there was really nothing of interest in the case. The UK court found that minimum contacts to establish in personam jurisdiction of the person of the UK officer of the company had been satisfied in the US, but that under UK law, it simply did not, our laws, our provisions, simply did not meet their standards of due process. And the UK court felt that Mr. Rubin, or it wasn't Rubin, Rubin was trustee, that the UK citizen was not treated as fairly as he would have been, say, in London or under the UK system, and refused to enforce it. It was a very basic due process argument. And so while there can be disputes about the center of main interest, I wonder if the creditors, let's say a LATAM creditor, comes into court in New York, gets his day in court, has a full-blown hearing or mini trial on that very question and loses, what would a Brazilian court do then?
Right. Yeah, I'll also obviously the attorney that's heading Latam, Celso, will talk after me for sure. But I think that one important issue is that Brazil has adopted the cross-border insolvency rules, which is the system, a post-universalism system. But at the same time, the law provides that Brazilian public policy and public, as the model law states, will always prevail. So, as you mentioned, these cases in which the court in the UK has ruled that there was an issue of public interest in public policy, which is due process, that will be applied by Brazilian courts also on the enactment of the new law, which should happen in a week. Currently, the defense of some of the creditors I've mentioned, very few creditors, is basically the fact that Brazil does not recognize this ruling in New York. It cannot be automatically taken to Brazil and enforced. It has to go to the Superior Court of Justice. And the new law mentions still a procedure of taking a ruling to the Superior Court of Justice. But after the enactment of the new law, of this bill, there will always be ample space for a party, a creditor, a defendant, to argue that public policy applies, and that since public policy applies, that is, as I think several commentators in Brazil mentioned, that will be the shield. The new law is, if you will, the sword, right? And the shield is the public policy. That's how the jurisdiction in Brazil will protect itself when there is an issue of public policy. But I mean, Celso is the guy who's heading this procedure. Maybe Celso would like to comment specifically on the LATA case.
Also, now that Judge Lobo has ruled and I've given the argument, let's tell us what you think.
No, sure. I have no doubt to say that this Brazilian party that has gone to New York, and then regardless of LATA, just from a theoretical perspective, Brazilian company with the Chapter 11 in the U.S., one specific creditor shows up in court, files a proof of claim, has any kind of litigation, then loses, and then decides to come to Brazil to litigate once again the same thing. I think the Brazilian party would be forbidden to do so. It doesn't depend on this new amendment because there's no law in Brazil saying that Brazilian parties could only litigate in this country, could only litigate in Brazil, and litigating abroad would be illegal. No, it's not illegal. There are so many arbitrations of Brazilian companies in Europe, in China, in New York, Brazilian companies involved in foreign litigation, and this litigation, they are all valid. So if a company shows up in court spontaneously and decide to challenge anything in a court of law, in this case in New York, if it loses, it could not have the same ability to rediscuss that again in Brazil, because otherwise it wouldn't make any sense. So if it goes well and the Brazilian party wins, that's okay. The U.S. decision is valid. If the U.S. decision is not favorable to the Brazilian party, and then the Brazilian party would have a second shot in Brazil. So it doesn't make any sense at all. And there's no specific law in Brazil, preventing a Brazilian company from going abroad to have an insolvency procedure abroad. And that's very important. Even though the Brazilian law obviously use it to deal with only Brazilian types of insolvency procedures, so true liquidation, judicial organization, and out-of-court reorganization, the law doesn't say a word saying that, well, if you're a Brazilian party, you cannot go abroad. I mean, it doesn't say that. So if the Brazilian process, in case the Chapter 11, is accepted by the US in this case, even though the party is not a US citizen, is not a US company, this is a valid procedure. First thing. The other argument that also did not depend on this amendment is the international cooperation. We should remember, and Otto is going to remind well, back in 2005, the Varig case was the first judicial organization, important one in the country. And at that point, there was an issue with the aircrafts, because pretty much, an airline without airplanes simply, it doesn't fly. It's quite obvious. So it's the main asset, let's put it this way. And then at that point, all the lessors, they're trying to get the possession of the aircrafts. And at that point, there was a need to prevent U.S. creditors, the U.S. lessors, from really taking over the airplanes. And three judges at that point, it was a committee of three judges in Rio, they spoke to Judge Drain, in the U.S. bankruptcy court, exactly to seek cooperation at that point. It was not even a Chapter 15. It was really a matter of cooperation. The judges they met in the U.S. jurisdiction very friendly cooperated with that, because it thought that, well, because of the cooperation, that would be possible. And the same thing, if we go to our Federal Rules of Civil Procedure, cooperation is there in terms of one country could, and Brazil should cooperate with any international country, any foreign country that would cooperate with Brazil as well. There will be certain paths to do so, but cooperation is there. And so, regardless of this amendment, and because of the reasons I've just mentioned, we truly believe that not only in the case that, well, a creditor show it up, because then it's quite obvious, but even for those creditors which decide not to show up, there, I mean, the U.S. decisions would be bound on there here in Brazil. And now with obviously the amendment, it's even more clear that there will be a specific route to achieve that.
Celso, on that cooperation point, I wonder, Pedro or Ulisses, may I show one slide here? Let me see if I can share this. This is, we talked about this in our prep session. Many of our courts.
We are at 62 minutes now. I mean, we can extend a little bit. We have one question so far. Okay, so we just monitor the time. Go ahead, please.
Yeah, so let me pull this up. This is an order that is in the, it's a standing order in the Southern District of Texas Bankruptcy Courts here in Houston. There are identical orders in New York and in Delaware. And it is an order that institutes essentially the UNCITRAL cross-border insolvency protocol. So for courts like Houston, like New York, like Delaware, that see a lot of international or cross-border bankruptcy cases, are those courts, and I'm here in Houston, but I also have a lot of cases in New York and Delaware. Those cases specifically, by an established procedure that is part of their local rules, have instituted these procedures. It talks about how the judges can establish their own protocol for communications, how creditors on both sides of the international divide, so to speak, can cooperate and can share information, and how foreign creditors would be protected in the U.S. case and vice versa. And in the cases we've seen, very often there is a counterpart insolvency procedure or proceeding or case in the foreign country. And the judges have been having when they get to a plan of reorganization, the judges have been having simultaneous confirmation hearings, sometimes by video. And then other times they'll have separate hearings, and then the judges will take a break and they will contact each other to say, I'm ready. The debtor has satisfied the requirements in the US. I'm ready to confirm the plan, but a condition is, are you ready to confirm your plan? And the foreign judge will say yes or no. And if he says yes, then both plans are usually confirmed at the exact same moment. So as these things, as Brazil becomes more accustomed to the protocol, I'm confident that you'll end up adopting similar procedures.
Yes, for sure, John. I think so. I think it comes with experience and culture. We've had a law now since 2005. It's been 15 years, and a lot has changed in terms of culture. I agree with what Celso mentioned in the our civil procedure code. There is a specific Title II, Chapter 1, Articles 21 to 25 of the Civil Procedure Code. And our law of introduction to rules of Brazilian law, Articles 12 and 15, it provides for international jurisdiction. So companies, they can accept the jurisdiction, and that's what happened in the Chapter 11. And I think that the cultural issue now going forward with the new law, and as Celso very well put, In 2005, the judges communicated using these several articles of Civil Procedure Code, and Judge Marcia Cunha even traveled to New York and did a joint hearing with Judge Drain, which is something very, very interesting. But there was no protocol. But going forward, I think the important issue is we know of the specialized judges of São Paulo, Rio, down south, and some other courts that already understand the cross-border implications of the new law. But as Celso mentioned, and you mentioned also, part of the issue is using public policy when there's a call for it, the equilibrium, and sometimes accepting these concepts of comity and non-convenient jurisdiction, and sometimes accepting that the main procedure will not be in Brazil. So this is a cultural thing that that will come into force. So I think Brazil is a big country, and when we talk about Brazil, we're not only talking about the courts in São Paulo, Rio, and some down south. So I think that the issue now is understanding how this happened abroad, understanding the culture, understanding how the system works, in order to be able to apply these cross-border principles here in Brazil. So,
do we have any audience questions, Pedro?
We had one, but it's been answered live. So we're all set with the questions. If the audience wants to submit questions after the event, we'll be glad to respond to it. BRATECC has all contact information. And so it's 1 hour and 8 minutes. I think it was an outstanding discussion, very timely topic. I would like to thank BRATECC, all BRATECC's team, Ulisses, Cid, Cecilia, Daniel. I'd like to thank John, Celso, and Otto for contributing to such an important event, and the audience, of course. And I hope to see the audience in a next event. And with that, I turn it back to Ulisses for closing remarks. Ulisses.
Yeah, thank you, Pedro, and thank you for all the panelists. Very interesting and enlightening discussions. I hope our members and the audience has taken advantage of all the good insights and the suggestions. And I look forward for the next chance that we have to get together. Thank you all. Have a good day.
Thank you. Bye-bye.